This is part 44 as far as our lecture series is concerned. During the last part, we started discussing provisions regarding appeals, right from section 372 up to section 394. And then, now this is the time for us to, try to understand as to what are the powers of the appellate court. Now, in order to know the powers of the appellate court, the first section that we have to refer to is section 386, which says, after perusing such record and hearing, the appellant or his pleader, if he appears, and the public prosecutor, if he appears, and in a case of an appeal under section 377 or section 378, the accused, if he appears, the appellate court may, if it considers that there is no sufficient ground for interfering, dismiss the appeal, or may, in an appeal from an order of acquittal, reverse such order and direct that further inquiry be made, or that the accused be retried or committed for trial as the case may be, or find him guilty and pass sentence on him according to law. Clause B says, in an appeal from conviction, reverse the finding and sentence and acquit or discharge the accused, or order him to be tried by a court of competent jurisdiction subordinate to such appellate court, or committed for trial, or alter the finding maintaining the sentence, or with or without altering the finding, alter the nature or the extent or the nature and extent of the sentence, but not so as to enhance the same. Subclause small c says, in an appeal for enhancement of sentence, reverse the finding and sentence and acquit or discharge the accused, or order him to be retried by a court competent to try the offence, or alter the finding maintaining the sentence, or with or without altering the finding, alter the nature or the extent or the nature and extent of the sentence so as to enhance or reduce the same. Subclause D says, if an appeal from any other order alter or reverse such order. And clause E says, make any amendments or any consequential or incidental order that may be just or proper, provided that the sentence shall not be enhanced unless the accused has had an opportunity of showing cause against such enhancement. Provided further that the appellate court shall not inflict a greater punishment for the offence which in its opinion of the accused has committed, and that might have been inflicted for the offence by the court passing the order or sentence under appeal. Now, this is as far as section 386 is concerned, whereas section 389 says, suspension of sentence pending the appeal, a release of appellant on bail. And it says, pending any appeal by a convicted person, the appellate court may, for reasons to be recorded by it in writing, order that the execution of the sentence or order appealed against to be suspended, and also, if he is in confinement, that he be released on bail or on his own bond, provided that the appellate court shall, before releasing on bail or on his own bond a convicted person who is convicted of an offence punishable with death or imprisonment for life, or imprisonment for a term not less than 10 years, shall give opportunity to the public prosecutor for showing cause in writing against such release. Provided further that in cases where the convicted person is released on bail, it shall be open to the public prosecutor to file an application for the cancellation of the bail. The Subclause 2 says the power conferred by this section on an appellate court may be exercised also by the High Court in case of an appeal by a convicted person to a court subordinate thereto. Subclause 3 says, where the convicted person satisfies the court by which he is convicted that he intends to present an appeal, the court shall, where such appeal being on bail, is sentenced to imprisonment for a term not exceeding 3 years, or where the offence of which such person has been convicted is a bailable one and he is on bail, order that the convicted person be released on bail unless there are special reasons for refusing bail for such period as will afford sufficient time to present the appeal and obtain the order of appellate court under subsection 1, and the sentence of imprisonment shall, so long as he is so released on bail, be deemed to be suspended. Subclause 4 says, where the appellant is ultimately sentenced to imprisonment for a term or to imprisonment for life, the time during which he is so released shall be excluded in computing the term for which he is so sentenced. Section 390 says arrest of accused in appeal from acquittal. When there is an appeal against an acquittal as per section 378, what are the powers of the appellate court? And it says, when an appeal is presented under section 378, the High Court may issue a warrant directing that the accused be arrested and brought before it or any subordinate court, and the court before which he is brought may commit him to prison pending the disposal of the appeal or admit him to bail. Section 391. Appellate court may take further evidence or direct it to be taken. And it says, in dealing with any appeal under this chapter, the appellate court, if it thinks additional evidence to be necessary, shall record its reason and may either take such evidence itself or direct it to be taken by magistrate, or when the appellate court is a high court, by a court of session or a magistrate. When the additional evidence is taken by a court of session or the magistrate, it or he shall certify that such evidence to the appellate court, and such court shall thereupon proceed to dispose of the appeal. Subclause 3 says, the accused or his pleader shall have the right to be present when the additional evidence is taken. And clause 4 says, the taking of evidence under this chapter shall be subject to the provisions of section 23 as if it were an inquiry. With this now, so these are the powers of the appellate court as far as section 386, 389, 390 and 391 is concerned. Now, section 387 lays down procedure regarding judgment of subordinate appellate court, and it says, the rules contained in chapter 27 as to the judgment of a criminal court of original jurisdiction shall apply so far as may be practicable to the judgment in appeal of a court of session or chief judicial magistrate, provided that unless the appellate court otherwise direct, the accused shall not be brought up or required to attend or to hear judgment delivered. Section 388 lays down order of High Court on appeal to be certified to a lower court, and it says, whenever a case is decided on appeal by the High Court under this chapter, it shall certify its judgment or order to the court by which the finding, sentence or order appealed against was recorded or passed, and if such court is that of a judicial magistrate other than chief judicial magistrate, the High Court judgment or order shall be sent through the chief judicial magistrate, and if such court is that of the executive magistrate, the High Court's judgment or order shall be sent through the district magistrate. Subclause 2 says, the court to which the High Court certifies the judgment or order shall thereupon make such order as are comfortable to the judgment or order of the High Court, and if necessary, the record shall be amended in accordance therewith. With this now, the two more aspects, namely, what happens procedure where judges of the Court of Appeal are equally divided, and section 392 says, where an appeal under this chapter is heard by a High Court before a bench or judges, and they are divided in opinion, the appeal with their opinions shall be laid before another judge of that court, and that judge, after such hearing as he thinks fit, shall deliver his opinion, and the judgment or order shall allow that opinion, provided that if one of the judges constituting the bench or where the appeal is said laid before another judge under this section, that judge so requires, the appeal shall be reheard and decided by a larger bench of judges. Now section 393 speaks about finality of judgments and orders on appeal, and it says, judgments and order passed by an appellate court upon an appeal shall be final, except in the cases provided for in section 377 and section 378, subsection 4 of section 384 or chapter 30, provided that notwithstanding the final disposal of an appeal against conviction in a case, the appellate court may hear and dispose of on the merits an appeal against the acquittal under section 378 arising out of the same case, or an appeal for enhancement of a sentence under section 377 arising out of the same case. Now, when there can be abatement of appeal is dealt as far as last section, namely section 394 of the Criminal Procedure Code of this chapter is concerned, and it says, every appeal under section 377 or section 378 shall finally abate on the death of the accused. So what is the effect of the death as far as two sections are concerned? 377 and 378, abatement of appeal. Every appeal under this section shall finally abate. Subclause 2 says, every other appeal under this chapter, except an appeal from a sentence of fine, shall finally abate on the death of the appellant. But then the proviso says, provided that where the appeal is against a conviction and sentence of death or of imprisonment, and the appellant dies during the pendency of appeal, any of his near relatives may, within 30 days of the death of the appellant, apply to the appellate court for leave to continue the appeal, and if leave is granted, the appeal shall not abate. And the explanation to this section says, in this section, near relative means a parent, spouse, lineal descendant, brother or sister. So these are the provisions as far as appeal is concerned, right from section 372 up to section 394 of the Criminal Procedure Code, with which you have dealt. With this now, when we start discussing the next chapter, namely chapter 30 of the Criminal Procedure Code, we shall be dealing with what do you mean by reference and what do you mean by revision. In order to understand the provisions of reference, we shall be dealing with two sections, namely section 395, The chapter starts right from section 395 up to section 405 of the Criminal Procedure Code, out of which two sections, namely 395 and 396, deal with reference, whereas right from section 397 up to section 405 are the sections which deal with revision. Now, during course of time we will learn that when there is no provision of appeal, because we have learned you can prefer an appeal provided it is provided by the provisions of the Criminal Procedure Code or any other law for the timing in course as far as section 372 is concerned. Now, when there is no provision of appeal, there is a provision of revision, and hence we shall be dealing with this section, namely section 397, and what is the procedure that is observed by the court exercising revisional jurisdiction, and then what are the powers as far as the court exercising revisional jurisdiction is concerned, with which we shall continue our discussion as far as our next part of lecture is concerned.